The Madlanga Commission of Inquiry has spent another day probing how political pressure reached into the National Prosecuting Authority and parts of the judiciary. What emerged from the testimony is not merely a tale of individual misconduct, but evidence that the separation of powers has been treated as optional by senior figures in the executive. That matters directly for the rule of law, because the Constitution does not allow the elected government to decide which cases get pursued and which are quietly buried. A former senior prosecutor described receiving repeated calls from a minister's office about a high-profile corruption matter. The calls were not requests for information. They were instructions on timing and emphasis. When the prosecutor pushed back, the matter was reassigned without explanation. The commission heard similar accounts from two other witnesses who had worked in different provinces. None claimed physical threats, but all spoke of career consequences that followed any refusal to align with political preferences. These details go to the heart of Section 179 of the Constitution, which requires the prosecuting authority to act without fear, favor, or prejudice. If testimony is accepted, it shows that requirement was routinely ignored. The rule of law does not survive by declarations alone. It needs institutions that can resist improper direction. When those institutions bend, prosecutions become instruments rather than independent exercises of public power. The commission also heard from a retired judge who sat on a special commercial crimes court. He recounted how dockets in certain politically sensitive cases were delayed for months before reaching his court, while unrelated matters moved quickly. He stopped short of alleging direct interference with judicial officers, but noted that the pattern of selective delay produced the same practical result. Some accused persons remained free while others faced swift process. This raises a separate constitutional concern under Section 165, which guarantees judicial independence. Courts cannot function independently if the flow of cases is controlled upstream by political actors. Critics of the commission will argue that testimony so far remains untested and that some witnesses carry their own grievances. That is fair. Commissions of inquiry are not courts. They gather evidence and draw conclusions later. Yet the pattern described is consistent enough to warrant serious attention. If the state cannot demonstrate that the NPA and the courts operated free of political direction during the period under review, then the public has reason to doubt whether any future prosecution or acquittal reflects only the evidence. The constitutional remedy is not complicated. The executive must restore the NPA's operational independence by statute and practice. That means clear rules against ministerial contact on individual matters, transparent criteria for case allocation, and protection for prosecutors who refuse improper instructions. Without those steps, the Commission's work risks becoming another report that gathers dust while the same practices continue under new names. At the same time, the testimony does not prove that every prosecution decision was tainted. Many cases proceeded normally. The danger lies in the selective erosion of standards. Once political actors learn that interference carries no lasting cost, the incentive to try again remains strong. The rule of law weakens incrementally, not in a single dramatic breach. The Commission still has weeks of evidence ahead. What it has already shown, however, is that South Africa's constitutional safeguards against executive overreach were not self-executing. They required people inside the system to push back. And too often that pushback was absent or ineffective. Restoring the rule of law will therefore demand more than new appointments. It will require structural changes that make interference both visible and costly. Until that happens, Public confidence in prosecutions and the courts will stay fragile, regardless of who holds office.